Hello, everyone. I'd like to welcome you all to our side event, which is called Future of International Justice, Accountability Mechanism for Grave Crimes in Ukraine. We are waiting for one more speaker. Today we've had a bit of a collapse on our roads in Kiev in Ukraine. We have very icy roads, and I think it's taken a little bit of time for him to get here. But I think we're going to start and he'll join us. So today's event is inspired by one of the recent discussions that we've had with the colleagues who are present today with us via Zoom, Eric Priya Pillai and Rod Rastan, and the event was titled Rome Statute at 40, and it was organized by Amnesty International and Arthur Institute. And during that event, we try to look at the future of the international justice system. And so today we are trying to, again, take a look at the future of international justice system, but in more practical terms, through the prism of the situation in Ukraine. One of the key ideas that was floating around during that discussion was the idea that we might be expecting from the International Criminal Court too much. And the temptation for countries like Ukraine is understandable in a way, because countries with weak legal systems, tarnished by armed conflicts, it's very tempting to sort of put your responsibility on something that is functioning more or less okay. Never mind when it's an institution that's supported by almost the entire world. So for us, it's very important to ask and then find an answer to the question where we draw the line between our responsibility to investigate and prosecute grave crimes and where it's actually okay to rely on the institutions such as International Criminal Court. Another thing that we need to take into account as well is that the International Criminal Court has a fixed mandate, whereas as the experience of Ukraine demonstrates, the modern lawfare is advancing, and the methods that are used are also advancing, and so are the violations. They become more diverse, if you like, and the combination of these methods also affects the extent and the degree and the scale of the pain and suffering that it's causing to the people. So the question for today is really how do we balance the nexus, and we find the nexus between the responsibility of a state whose weak legal system is not capable of ensuring justice and accountability, and then the role of the International Court in the situation. And that's obviously looking from the perspective of Ukraine's obligation, or rather responsibility, to ensure the adherence to the principle of complementarity. We have a fantastic panel with us. I can't actually believe how lucky we have been to get everyone to participate in this event today. So we have Valeria Melnik. She is the prosecutor of the Department for the Supervision of Crimes Committed During Armed Conflict at the Office of the Prosecutor General of Ukraine. We will have Arkady Bushenko with us, who hopefully is going to join us in a few minutes, and he is the judge of the Criminal Cassation Court, the Supreme Court in Ukraine. Then we have Katrin Wellhammer, head of the National Justice Program at the Justice Rapid Response. We also have Eric Whitty, who is Senior Policy Officer at the Open Society Justice Initiative, and who is also a creator of the best book ever called Options for Justice. I mean, it's very practical, and whoever hasn't seen it yet, I highly recommend it. And we also have Priya Pillai, who is an international lawyer and head of the Asia Justice Coalition. And finally, we have Rod Rustan with us, who is the representative of the Office of the Prosecutor of the International Criminal Court. So with the panelists, we will try to answer the question, where do we go from the situation that we currently have, whereas on the one hand, we hoping that the International Criminal Court will open the investigation into the situation in Ukraine, and on the other hand, how we ensure that whatever is not looked into by the ICC, Ukraine is capable and, well, able and not so much willing, but maybe willing as well, to prosecute and ensure accountability. We also have Liz Evanson with us. She's from Human Rights Watch. I think almost everybody should know her by now. So she will be helping me to stir the discussion in case I decide to go off track a little bit. So I think we should begin. And my first question for Valeria, and I know that, well, before the department was established a year ago, the situation with the investigations and prosecutions was very dire. There was no system in place, everything was dispersed throughout the country, and now you guys are trying to sort of put it all together and make some sense of whatever is going on. But I also know that you're still facing a lot of challenges. So if you could sort of introduce and speak about those challenges for us, and also what are your expectations as the representative of the legal system of Ukraine from the work of the department in the future?
Thank you. My name is Valeria. I am the prosecutor in the department for supervision of crimes committed amid the armed conflict, Prosecutor General's office. And speaking about situation, I want to say the next, that Ukraine initiated an investigation at the national level in order to establish violations of international humanitarian law and identify those responsible for committing grave crimes, war crimes, crimes against humanity. But at the same way, there are some objective obstacles that indicate that Ukraine, although it wants, it cannot conduct effective investigation and hold accountable those responsible for the crimes under the Article 17 of the Rome Statute of International Criminal Court. And first of all, of course, the main obstacle for us is the absence of access to the temporarily occupied territories of Ukraine. We are talking about Crimean Peninsula and some districts of Donetsk and Lugansk regions. And this, of course, negatively affects the ability to investigate effectively and comprehensively investigate criminal proceedings and conduct investigation actions directly at the place of commission of such crimes. And then many victims and witnesses and suspects of such crimes, they continue to reside on the temporarily occupied territories. Thus, there is obstacle to directly interrogate them. And of course, I want to mention a very serious obstacle. It's time limits for pretrial investigations. According to our Criminal Procedure Code of Ukraine, we have Article 219, which indicates that pretrial investigation should be completed within 18 months after the time of committing the grave crimes and crimes of special gravity. And of course, this is some kind of absurd because, as we know, war crimes they don't have a statute of limitations at all. But at the same time, according to our legislation, they have time limits for pretrial investigation. So, of course, it should be changed. And also, I want to mention our possibilities in procedure in absentia during the absence of suspected persons. Although our legislation allows this procedure, but in order to start it, to establish it, the person should be announced in the international search. But in practice, Interpol declines our applications to put the person, the suspected person, into the international search list. Considering that such investigations, they are politically motivated. So it actually hinder our application, our ability to start in absentia procedure. And then next, Ukrainians' capabilities is restricted with the immunity enjoyed by high-level officials of Russian Federation. And according to the 27th article of the Rome Statute, ICC does not have such an obstacle to start investigation. And also, we have only one article, it's 438 in our Criminal Code of Ukraine, violation of the laws and customs of war, but it is so generalized and refers to many international documents. So what we have actually that many grave crimes committed at the same place and in the same time, they could be qualified differently. One of them as a war crimes and another one like a general or ordinary crimes. And of course, this is wrong because war crimes are one of the most serious crimes known to the mankind, which threaten peace and well-being of the world. And we don't have a responsibility for crimes against humanity in our criminal code, but we hope for implementation those norms into our legislation as soon as possible. And we know that draft law is currently pending in the parliament, and it intends to implement international humanitarian law into our legislation. I also want to mention about lack of institutional infrastructure, because yes, we know now we have a specialized department in the structure of Prosecutor General's office, but at the same time we don't have specialized departments in the pre-trial investigation bodies, and we don't have specialization in courts. So, of course, there is a need for such specialization. And, of course, we need to create a personal reserve, which will include special trainings and certifications for the law enforcement professionals, prosecutors, investigators, and civil servants and other professionals who works in the field of documentation and investigation of war crimes, and also to create a special reserve of civil servants for fulfilling the position after when the occupied territories will be liberated from occupation. And so we should enhance a personal reserve both in quantity and in quality. So this is the main obstacles I've just mentioned to you, which we face now.
Okay, great. Thank you, Valeria. Yes, we've had a number of regional discussions throughout the past 6 months with the professional community here in Ukraine, among whom we had judges and prosecutors and lawyers. And very often what we've discussed was, of course, yes, the department has been established, but it's practically functioning in isolation because there is no the actual system in place. There are no we call them mirror departments, and they investigative level. So there is no particularly responsible body for these types of investigations. We also don't have specialized chambers or any kind of special structure at the court level. And I think this hugely affects, I mean, in addition to the lack of legislation, of course, in place, the whole system is just essentially defunct. I don't know, maybe we're going to hear from Arkady now, and maybe he will tell us something different. So I'm going to pass the floor to him now.
Good afternoon. I have to be careful given my status of a justice of the Supreme Court. However, I think I may state that to date we haven't had a consistent strategy with regard to investigation of war crimes and prosecuting war criminals today or at any time in the future when it becomes possible physically, logistically. Well, at any rate, I understand the complex nature of the conflict and evidence collection, but they have to be collected because they tend to disappear over time. If in the future we want to bring war criminals to account, and if we want to demonstrate to the members of the society that we do take certain efforts to this end, there should exist some sort of a strategy of investigation and prosecution. Well, as far as the Supreme Court is concerned, we don't get too many. Well, actually, we get very few, if any, war crimes cases. Yes, we consider cases related to terrorist acts or participation in terrorist organizations, and verdicts, judgments are meted out. Myself, I haven't had a chance to sit on cases like that, but there are certain problems with investigating participation in terrorist organizations because the status of the formations acting in the occupied territories is vague. Can they be regarded as terrorist organizations? Also, there aren't any legal instruments that would refer to those organizations as the terrorist ones. Well, politically, there are some statements here and there, some rhetorics, but for a judgment to be passed, this seems a shaky foundation, and I doubt that those judgments will stand at the European Court of Human Rights if complaints are made. before that court. Well, of course, a judge may decide that a person is a member of a terrorist organization, however, only after having looked into all the facts supporting this assumption. And as a matter of course, judges don't have all the facts available to them. There are only statements to the effect that a person had joined a terrorist organization, and this could present a problem if cases like that are taken to international tribunals, because this may raise issues of lack of certainty of law and lack of reasoning to support a conviction. I also think that this is largely the diffusion of resources, and we have a lot of cases arising from the acts that do not present a significant social danger, whilst war crimes, I can't seem to see any substantial evidence presented by our law enforcement to support their charges. So this brings to a certain bias, so to speak, or disbalance in bringing to account persons who've committed some petty offenses, whereas it can be assumed that much graver crimes are committed, and this diffusion of resources may really be a reason why we don't have a lot of success stories in investigating. Well, I understand that law enforcement may have something in the pipeline, some cases that are too early to be made public, and I welcome this reserve of our law enforcement agencies, their reluctance to make certain investigations known at this time. Again, politically speaking, the rhetorics at the national level has changed, and de facto authorities in the occupied territories are no longer called terrorist organizations, but because a conflict is still looming that'll have to be resolved at the legislative level. That is to say, to call persons who were fighting against the armed forces of Ukraine as combatants or war criminals. I understand that this is a very painful and painstaking process for the lawmakers. Any revision of the rhetorics tends to cause revolt in the society. But we are now discussing the legal aspect, and legal professionals should not be governed by the perceptions in the society and then the popular attitudes towards people who may be affiliated with the separatists, but this is no ground to call them criminals. So this is something that should be resolved at the national level. I agree that our criminal code should be better organized with the international law on war crimes. This process is taking too long. The war is going on, has been going on for 6 years, but no significant developments have come into the open in the legislative field. And if I think that some international pressure might precipitate the lawmaking process in the Ukrainian parliament. That said, I believe that there are some signs showing that the main, so to speak, burden of investigating crimes committed by the adversary is on the Ukrainian authorities. I'm saying that because earlier in 2014 or early 2015, there existed a belief that it would be the International Criminal Court, and we could just wait and see. The ICC will deal with the matter, will decide who's wrong and who's right, will collect all the evidence and bring, so to speak, to account those who we call, well, scoundrels, but more recently, understanding of the fact that ICC is a complementary body and cannot therefore replace our law enforcement system. Maybe this awareness will help resolve many of the challenges
We have a
that
quick
my
question
colleagues
from
have
the
been talking
audience
about.
to you, Arkady. The question is about whether the lower court instances, like the first instance and appeal, Court of Appeal, apply to the Supreme Court and ask the Supreme Court to interpret or to give the explanation or to express the position on the investigation or prosecuting such cases.
Well, to start with, the law does not provide for such an opportunity of seeking, so to speak, position interpretation of the Supreme Court by lower courts. Yes, we can make our opinion only when a judgment is challenged before us. All other forms aren't used. Some say that the Supreme Court might reinstate the erstwhile practices of the plenary session resolutions or explanatory resolutions. I, for one, would not be very supportive of that. Far as I'm concerned, nobody ever called me asking for my, so to speak, advice. In other words, the Supreme Court may only state its position
Okay,
when
thank you.
it
And we've already
considers
established that these
complaints.
cases don't reach the Supreme Court, typically. Okay, so yeah, and I just wanted to add to what Arkady said as well, also from our experience from these regional trips that we've done with the other judges, that one of a few other issues were highlighted during those discussions. It was the issue of independence, especially it concerned those judges who work in the conflict zone area or close to the contact line. Regional courts, they don't feel secure and safe in adjudicating in such cases. And also they very often they mention the lack of resources in their courts, which is a huge problem. Okay, so we are done with the domestic block of the discussion, and we're going to move on to our international colleagues. And first, we're going to hear from Katrin from Justice Rapid Response, and she's going to talk to us about their experience in dealing with and giving expert support to the states who were in a similar position as Ukraine, struggle with the domestic legal system, and how these investigations and prosecutions, sort of what challenges the other states are facing, and maybe we can find and identify quite a few similarities with Ukraine. Katrin? Thank you.
Thank you, Nadia. Can you hear me?
Yes, we can hear you. Yes.
Excellent.
Great.
Excellent. So I would like to start by thanking the Ukrainian Legal Advisory Group for the invitation. I'm really delighted to be able to represent Justice Rapid Response in this discussion, especially among such distinguished panelists. So thank you very much. Maybe I should start with a disclaimer, and while I will address some of the common challenges that we see in facing the national authorities dealing with international crimes, obviously every country is unique, has its own sets of challenges when it comes to accountability and justice. And also every actor within each country has its own needs and challenges. So here I won't pretend to do an exhaustive list. I really will focus on sort of the experience we have gathered at Justice Rapid Response in the context of supporting national authorities in a number of different countries. Maybe for those who, very briefly, for those who don't know Justice Rapid Response, we are an organization that was created to support the international community to investigate international crimes. And we do that through a roster of experts from around the world, representing a wide range of expertise that is needed for these kind of investigations. And we deploy these experts to international mechanisms such as the ICC, but also national authorities like the specialized department in Ukraine, but also civil society organizations working on these crimes. So really, I will focus on the common challenges that we have seen most often. I have the benefit of coming after Prosecutor Melnik and Judge Buchenka, who've already raised some of those issues. I mean, the first one was definitely the legal framework, lack thereof. And I won't go into much details because, of course, that was covered very eloquently and illustrated very eloquently by Prosecutor Melnik. About the different challenges, whether it's substantive law, sort of, in Ukraine, the lack of crime against humanity provisions, for example, or procedural law, and she mentioned the time limit, so I won't dwell on that. The second challenge, very much also mentioned, is the evidentiary challenges, and that, of course, applies to both evidence required to prove the elements of crimes, but also the elements to establish the criminal responsibility of individuals for those crimes. International crimes obviously tend to be committed in the context of an armed conflict or period of dictatorship and so on. So the collection of evidence will most likely be a challenge, and Prosecutor Melnik already mentioned the question of access, which is specific to Ukraine. But there can be also the question of the time that has elapsed between the commission of the crimes and the investigations. Crime scenes won't be available anymore, or witnesses won't be available anymore, or as reliable with the passing of time. Other issues, such as the questions of capacities around sort of very technical aspects, when sort of mass graves are involved, so forensic expertise typically can be some of the issues related to evidentiary challenges. And what I wanted to say about the evidentiary challenges is that it's not only relating to the collection of evidence, but also what we have found is even in contexts where collection of evidence isn't so much of an issue, the management and analysis of that evidence is a huge challenge, particularly when dealing with complex cases of international crimes. National authorities don't necessarily have the experience to deal with a large amount of evidence and analyze it in a way that will enable them to, identify patterns, linkages between facts, between perpetrators, individual victims or group of victims. The third challenge I wanted to mention is the question of prosecutorial strategies and case building. How to approach the cases, which ones to tackle first, which ones to address jointly, etc. But also on the question of building cases, complex cases. These cases often have multiple perpetrators that can be found at different levels of the chain of command. And one of the things we see in several countries we work in is prosecutors struggling to link alleged perpetrators who are often far removed from the physical commission of the crime at the time of the crime. And so, that of course links also back to the legal framework. Sometimes the modes of liabilities will be limited under the national legal framework, but also the question of evidence that I raised earlier. Then there's definitely the question of witness management and witness protection. We consistently come across that challenge at the national level. And when we raise the question of witness protection, we often hear about legal witness protection frameworks available, or the protective measures that can be requested and granted by a judge. But of course that's part of the answer, but we often find that witness protection in a more informal manner is not integrated in the work of the investigative and prosecutorial process, through the informal measures that can be taken, including considering how to communicate with witnesses, where to meet with them, how to refer to them in case files and things like that. And of course, that sort of feeds into the other challenge I mentioned before on the evidentiary challenges, because of course, if witnesses don't feel that investigators and prosecutors have their protection top of mind, they are unlikely to want to come forward. The fifth challenge I wanted to mention is victim participation. Again, invariably, it's a challenge. Now, victim participation, of course, varies greatly from one jurisdiction to another. This said, in any system, whether or not victims can formally participate in proceedings, investigators and prosecutors should be equipped to engage with them. And I think this is critical because investigators and prosecutors tend to focus very much on the perpetrator, which for obvious reasons. But I think when it comes to international crimes, because of the nature of the crimes, the focus should be on both perpetrators, but also very importantly on victims. And that's where it's really important that, investigations and prosecutions have at the forefront or integrate a victim-centered approach to their work in order to ensure sort of successful accountability for these crimes. The last two challenges I wanted to mention briefly, and they're coming last not because they're less important, on the contrary, but more because they interact and sort of are cross-cutting to the other challenges I mentioned, is first of all the investigation of sexual violence. In most contexts we've worked in, we have seen that the investigation of sexual violence is somewhat of an afterthought. It's usually something that comes later in the process, sometimes only because civil society organizations representing survivors have drawn attention to the gap. And so sexual violence is typically not integrated into the investigations from the start. And as a result, most of the time they are completely overlooked or considered sort of incidental, collateral kind of crimes to international crimes. And even even in contexts where authorities pay attention to sexual violence, their approach to investigating these crimes tend to not be adapted to the nature of the crime and to the needs of the survivors. Lastly, again, a common challenge that we see is the lack of sort of application of a differential approach. And we frequently refer to the lack of integration of a gender lens or gender perspective into investigations, and that's certainly something we see very often lacking. So a lack of sort of considering specifically the gender identity of the victims and analyzing the commission of the crimes in that context. And the impact of the crimes on victims. And of course, applying that gender lens shouldn't only apply to sexual violence crimes, but of course to all crimes committed. And that same approach should be also, afforded to other groups. I'm thinking of, minority groups or children, for example. So these are really some of the common challenges that we've seen over the years working with national authorities. But I would like to say that, I've been focusing on investigators and prosecutors, but I think, of course, it's, judges have an extremely important role to play, of course, in successful delivery of justice for international crimes. And judges will have challenges that are specific to them, but they will also share some of the challenges that I've mentioned, typically the legal framework challenges, but also for sort of understanding, for example, sexual violence as an international crime. And more we see across the world, countries making mandatory sort of SGBV training for their judges, recognizing the importance of that. Maybe I just want to also normalize a little bit these challenges because, these are the very same challenges that investigators, prosecutors, and judges have had and have faced at the international level. And some of those challenges persist still today. It took years and years to develop investigative and prosecutorial capacities at the international level. And things like victim participation is still, took years to be considered and is still a challenge. So I just want to sort of normalize that and say, I think it's very welcome that Ukraine has created last year the specialized department on the one hand, and also it's also very welcome that the department is very willing to turn to the international community for support, including with Justice Rapid Response, but also our colleagues from the Global Rights Compliance, to address some of those challenges they're facing. But as we've heard, I think that's one part of it. There's also the question of institutional framework, and I really look forward to hearing our colleague Eric discuss the different models. I don't know how I'm like with time. I'm turning to the moderator if you want me to also address sort of challenges we've faced as Justice Rapid Response, or should I leave it to this?
No, I mean, you can if you may if it's not going to take too long.
No, I'll wrap it up in 2 minutes then.
Okay,
thank you.
Great.
Maybe just to talk about challenges we have faced as Justice Rapid Response. I mean, definitely there's again plenty of them, but I'll mention just a couple. The political will is a challenge, in pretty much every context. There is really no context that is ideal. Political considerations always come into play. So, of course, it's something we assess going in, but throughout our engagement. And I think for us, it's really a matter of finding the adequate political will, a level of political will with the main actors and the main drivers of accountability in a country. Finding the right people, extremely challenging and important. And this is why Justice Rapid Response has this roster of, now 700 and so experts from everywhere in the world with extensive experience. But it's not just about the experience and expertise. It's about, the skills of those professionals to be able to tailor the lessons learned and best practices to the context in question, which is very important. And finally, sort of a more practical consideration. In some countries, the language will be an issue or a challenge in our engagement. And we have, among the 700 experts, we have 100 nationalities and close to 100 languages, but still finding the right, as I said, the right expertise, the right set of skills, plus the language sometimes can be challenging. And when we work with interpreters, as we have in Ukraine, it can be a challenge. With all due respect to interpreters who do an extremely difficult job, some things like get lost in translation. So I will leave it at this, and look forward to hearing and engaging in the Q&A maybe later on. Thank you.
Thank you, Katrine. I think, yes, political will, that's probably the brightest. I've heard everything and I agree. And I think we echo here a lot of the, almost all of the challenges that you've mentioned. Some of them probably we haven't identified for ourselves as such yet because we are not at that stage yet. But I'm sure they will at some point become very relevant for Ukraine. But yes, the issue of political will is something that we're definitely going to be discussing today. But first, I'm going to pass the floor to Eric. And I'd like you to tell us about the existing experience. Obviously, Ukraine is not the first one and not last country in the world who is faced with this set of challenges, and we have a long road ahead of us. So, is there a recipe that the world can offer us in order to tackle all these challenges? Thank you.
Thank you so much, Nadia, and thank you to the Ukrainian Legal Advisory Group for putting together today's discussion. A recipe, I think the short answer to that is no, but it's encouraging to hear where the discussion is now. Justice Bishenko mentioned that, it used to be widely thought that the ICC was going to come and take care of the war crimes problem in Ukraine. And now that there's broad recognition that even if the ICC opens a full investigation and takes some steps, there might be a handful of cases at most, there's still going to be a huge impunity gap that needs to be filled by Ukrainian institutions or some kind of internationalized or hybrid model. And so, yeah, we've heard about the important steps taken already, including the establishment of the Special War Crimes Unit in the Prosecutor's Office, and that's very encouraging, but also the ongoing challenges. And it raises the question of whether more is needed. And in thinking about whether new kinds of mechanisms can be applied in Ukraine to complement what already exists at the domestic level and with the ICC, it's good to think about other experiences. And you mentioned our handbook, thank you for that, called Options for Justice, which has also been translated into Ukrainian by colleagues at the International Renaissance Foundation, and is available through their website. So in putting together the handbook, there have been so many previous models of justice since the early 90s in particular to learn from. And for every country, it's going to be different. And so you can't just say, well, there's one great model and we should apply it everywhere. This is the answer for Ukraine. It really has, the lessons have to be drawn from all of the previous experiences and the solutions really tailored for Ukraine's specific needs. And so we looked at 33 different models in 29 different countries and came up with questions of design across several different categories. And foremost, the question is, what's needed? What is the purpose of any additional mechanism? And we've heard today, I think, some of the answers to that question, needs of capacity, of more resources, of expertise when it comes to prosecutorial strategy, conducting and managing complex investigations, interpreting international humanitarian law, international criminal law. building domestic capacity for the longer term, because if you bring in an internationalized or hybrid mechanism, it's not going to stay forever. And I think the ideal anywhere is that eventually mechanisms should be entirely domestic, and there shouldn't be this reliance on international expertise. The question is how you get from a situation where there are capacity shortcomings, there are these additional challenges, to a situation where the domestic system is capable of doing it on its own, from the investigation through prosecution to adjudication, with adequate defense, with victim representation, strong witness protection, and all of the other needs associated with grave crimes trials. And so, you know, they're based on the discussion of needs so far, I think it does point to some kind of international involvement for some period of time. And there's a question of what that looks like. And there have been a range of experiences. Sometimes international officials have been inserted directly into specialized departments at the national level and essentially become part of the domestic justice system for a period of time. And that's what happened in Bosnia and Herzegovina with special prosecutors' offices and war crimes chamber and similar institutions for dealing with organized crime and corruption. And one interesting sort of way that worked in Bosnia was that from the beginning, there was a phase out of international participation planned in. So at the beginning on a judicial panel, there would be 3 international judges and 2 national judges. Over time, after a couple of years, the majority flipped, and there were 3 Bosnian judges and 2 international judges. And then it was 4 and 1, and now today it's all Bosnian, and there are no internationals. And the same thing happened in the prosecutor's office, where the internationals eventually phased out. And so there are positive and negative lessons to be learned from that experience. That kind of direct involvement by internationals often requires amendment to national law to make it possible. And so that raises questions of whether it is politically possible in Ukraine to amend laws as needed to allow international investigators, prosecutors, judges, potentially, witness protection experts to operate effectively as part of Ukraine's domestic system. But there are other models as well. If internationals are not directly acting within a system, they may be mentoring nationals and operating in that capacity. And an interesting model we've seen is the International Commission Against Impunity in Guatemala, called CICIG by its acronym in Spanish. And this was a UN-backed model that had a mandate not related to grave crimes per se, international crimes, but it was mandated to advance judicial reform in Guatemala, to dismantle organized crime networks in Guatemala, and to build the capacity of the national judiciary. And it was a spectacular success. And it really provided political cover for national prosecutors and investigators to go after, to pursue cases regardless of the difficult politics. It successfully built the capacity, by building cases alongside Guatemalans that were then tried in Guatemalan courts, brought to court by Guatemalan prosecutors. It really built the capacity of national justice system operators. And it had then a knock-on effect on the Attorney General's office ability to bring cases related to Guatemala's conflict. The war crimes cases, crimes against humanity, even a genocide case against a former head of state, previously thought untouchable. And so you had both this element of capacity, but the international presence also gave some political cover to national officials who previously had been very susceptible to political pressure, not to pursue investigations or to pursue investigations against political opponents. It really ended a lot of that. And so I think is really a model, the type of model worth considering, where essentially you might have international legal professionals operating in the country, working to help build cases, working to help with prosecution strategy, working to help with witness protection issues, perhaps advising judges on international criminal law and how to interpret it when cases do reach the courts, and really working across all of the different facets of the process. And so I think though when you do bring in internationals, there shouldn't be an assumption that just because somebody is international, it's automatically going to improve the situation. That there's automatically going to be expertise, objectivity, and so forth. That's the ideal. But there have been a fair number of negative experiences or mixed experiences in previous internationalized institutions or hybrid courts and at the international courts today. There are people who are not there for the right reasons because they're overpaid, because whatever. So in the recruitment, it's not enough to ask about experience and ask about credentials, but really also about open-mindedness. Are these people, especially in a context where they're coming into a foreign country, into a domestic system that has very capable individuals working within it and a lot of goodwill domestically? How do you bring in internationals who are open-minded and collegial, not there to lecture? Of course, they're available to try to impart their expertise in a collegial way, but also willing to learn. And that's really important. Not arrogant. You don't want somebody who's arrogant. So I really think that's vital if you're going to bring in an international element, to really think through how you set up the right recruitment, the right incentive structures to bring in those people who really are well-intentioned, highly motivated for the right reasons, and will really have the greatest positive impact. And so I'll just conclude by sort of reiterating what others have already said, Katrina especially, that you can't just sort of copy and paste a model. It has to be adapted to the particular needs. Those needs have to be defined by Ukrainians. There's a large amount of political will involved in setting up any kind of new mechanism. And I think an initial test of any kind of political will along those lines is the current draft law on the domestication of international crimes in Ukraine. If that law can't be passed, I think that raises real questions about Ukraine's political will to create any new mechanism that would be sort of more ambitious in tackling these challenges.
Thank you, Eric. It's very interesting and very useful, as always. Well, I just wanted to address some of the points that you've made. I mean, and that will take us on to our next block of discussion and next speakers. I think yes, the question of political will is probably the key ingredient, and so far, I don't know, colleagues may not agree with me, but we've faced the biggest challenge in that regard. I mean, we hope that Ukraine is about to harmonize its law with IHL. We're waiting for the second reading of the draft bill, which hopefully is going to take place in the next couple of weeks. But there's another challenge, which is a bigger one for us, I think, and it's the changes to the constitution that would need to happen before we could actually introduce any international element into our system. And I mean, the question of political will is a very slippery one, I think, anyway. And like with the mechanism, it's also very unique to each country, I suppose. But I guess the best way for us to tackle it is to learn from the existing experience as well. And that's why I asked Priya Pillai to join our discussion today, because she's the head of the Asia Justice Coalition. And this is a successful experience that I hope that we can draw from as well. And Priya, could you just share it with us? Tell us why and how, and what's the future? Thank you.
Thank you very much, Nadia, and thank you to the Ukrainian Legal Advisory Group for inviting me for this panel. And I think they're very esteemed co-panelists this evening, so I'm really honored to be here with you. I want to say that actually your invitation has really made me reflect. And today I've really been thinking about what we mean by a coalition, how we've come about, what the plans are, and trying to extrapolate lessons that I have learned that might be useful to you as well. So I think what I would like to do is really speak about some of the lessons that we've learned, some of the experiences from the coalition. But I think situating the question, which the last two speakers have spoken about and that you've also spoken about, which is political will. I think in every discussion around international justice and maybe justice more generally, we always hear this question of, is there political will? And I think for me, I think it begs the question also, what does that mean? What do we mean when we say political will? Is it political will that is created internally? And is this something that we can create ourselves? Is it internal pressure to push legislators, to push government functionaries to do certain things? Is it also external pressure? Is it pressure from the international community more generally to say, these are things that need to be resolved, or these are questions of justice that need to be resolved within the country as well? So I think we can look at political will and maybe the way to generate support or generate sort of some of this pressure internally as well as externally. So I think, those are two levels that we need to think about as well. I think in terms of political will, it also means establishing and generating critical collaborations within citizenry, within groups within a country that have particular aims. And essentially, I think it's a question of empowerment as well. And I think when we are talking in a very particular instance, such as in Ukraine or such as in the context of Myanmar, we're talking about legal or political reform. And we're really talking about very key, say, provisions of law that we want to either challenge or that we want to reform or that we want to change in a way. I think this is where there is a space for collaboration, and there's a space for really critical connections in a way that can help us advance in this process and help us take steps to sort of move forward. I think with that sort of broad sort of overview or approach, I would say, and just for your viewers as well, I think just a little bit about the Asia Justice Coalition, which is quite a small coalition in comparison to many others. It's a coalition of 11 organizations, national, regional, and international organizations that are focused on justice and accountability in the context of Asia, and looking specifically at the Rohingya issue and looking at Myanmar right now. The way I see it is a coalition is a strategic way or a strategic approach to dealing with the question of political will. It's one approach. There are many other approaches, I think, as well, but I think it's one way of saying, is there a way we can generate engagement? Is there a way that we can generate certain demand or support for what we want to propose or what we want to make sure moves forward? And I think the coalition is one approach, and I think it is a very good approach as well. I think at its most basic, most fundamental, I think the question is, what is a coalition? A coalition could be a network, a group of people, a network of people, individuals as well as organizations that really have a common aim or a common purpose. And I would say one of the key ingredients really is this clarity of purpose. What is it that the organizations or the individuals as well are looking to achieve? What is strategically the aim of getting together in this group? Because there are, positives and negatives as well. So I think that is a critical factor to think of really what is the clarity of purpose in terms of moving forward. Having said that, I think the other big factor is really having certain guiding principles, certain ways of working that everybody is quite clear on. And of course, I think the idea of a coalition also is that it evolves. It's something that's not set in stone. It's a group of people. Sometimes the aim or the initial, idea that you have going into a coalition might change a little bit with developments. And I think that flexibility has to be built into the coalition and built into the way that any coalition works as well. So I think in terms of, guiding principles, for instance, the Asia Justice Coalition, we have 4 guiding principles, and they're quite broad, but I think they do cover a range of aspects that you need to keep in mind when you're working together and when you're moving forward together on these issues. So the first I would say is, of course, it seems the most obvious, really, collaboration. But I think the question is also the details. What do we mean by collaboration? Is it that you're collaborating on one particular project, or you're collaborating on one particular instance of, saying we want this one case, one emblematic case to move forward? And is that the reason why we're going to work together? Or is it broader? Is it that we collaborate on a range of activities or a range of ideas? And the way we might collaborate on each of those, again, might be a little different. So I think, that idea of collaboration is something that is a big banner, but under that, there are multiple ways of approaching collaboration as well. But I think at the end of the day, it is about sort of working together and using each other's strengths in these specific areas that you need to basically move forward. The other guiding principle I would say is complementarity. And I use this a little differently from when we talk about complementarity at the ICC. I would say here complementarity, you're really talking about, for instance, in our coalition, we have some organizations that are more regional in focus, some are more international in focus. Here we're really saying complement each other's strengths. So if you've got a bigger sort of footprint, or you have stronger connections in generating that political will, for example, with ASEAN, with the Association of Southeast Asian Nations, or a regional grouping in the area, then that's something that we should leverage, as opposed to an organization which has more sort of in-depth knowledge of the national context, and that they should be then focusing on that. So that every point sort of complements each other, and that every organization complements each other in working towards a particular goal. I think having said that, there's the other question which I think is also critically important, which is the question of independence. And, while you have a coalition which is maybe broad-based, which has a number of organizations, I think there needs to be that realization that each organization also retains its independence, that it doesn't give up its aims or goals to just this one larger purpose, that it still keeps its individuality in a way, and that actually contributes to the strength of the coalition overall. So I think, sometimes that doesn't seem sort of like something that is a natural part of coalition building, but I think it's very important to keep that in mind. And that is also critical for organizations to feel that they can be part of a coalition, but can still, have their plan of action, that they still have their individuality and their sort of individual personality in a way. So I think that becomes quite important. And of course, I think the last guiding principle I would say is transparency, where members of a coalition are open and are transparent with each other and basically are quite clear about what their positions are on certain things, and that they are able to communicate that effectively. And then based on that, the coalition as a whole, decides if it's going to move forward on a certain point, how it's going to move forward. So it's not just about moving forward, but it's about what are the strategic ways that a coalition can move forward and, try to effect a change. So I think, those are, larger questions that whenever you're thinking about a coalition, you need to keep in mind. What I would also say is in terms of the types of organizations with coalitions, this is, I think, really critical as well in terms of leveraging the strengths of different organizations. As I mentioned, if you have a mix of national, regional, international, it's essentially you're looking at complementing the work of each of these organizations and really ensuring that either if you're looking at an advocacy position or you're looking at a specific legal question, that you've got the skills and the expertise and that you can draw on each other, you can draw from each other. So I think that's, again, something that's very useful. Also, just in terms of, I think as Katrin and Eric have mentioned, that there are examples from around the world that you can draw on as well. And I think that sometimes becomes critical in saying, well, we faced some of these problems elsewhere, and these are the approaches we've taken. Maybe it's not, totally adaptable to one particular context, but we can use elements of it. So I think that's, again, something that we really need to keep in mind and just make sure that we have, as you think of a coalition. I'll just make one or two other small points, which is coalitions, I think, are also sometimes a matter of timing, really depending on what is the development, legal or policy development that is taking place, that you want a larger group of organizations to rally around and to really work with to make more of an effective point. I think from that perspective, I would really say there is strength in numbers. The key sort of focus of any coalition is that you can make a collective point and that might be stronger and more effective than if it's one organization making that point. So I think that's something that is really important. But along with it, also the fact that you have diversity, that you've got different approaches within a coalition. Everybody may not agree all the time, but I think that's what gives a coalition strength and ensures that it sort of builds and grows and is more effective as well. And, I think with that, I'll stop. But just to say that it is sometimes a longer journey, but I think there are really, really reasons why a coalition could advance certain specific legal or policy points that might be more difficult to do, for an individual organization. So, yeah, so I'll stop here, but I'm happy to answer questions as well.
Great, thank you, Priya. That was very helpful. I just wanted to make a point as well in regards to what you've said. Liz and I also were discussing at some point what the coalition, if we ever to go ahead and on this project and start and create one here, what the purpose, the goal of the coalition would be and how you define it. Because if we start looking at the one layer, for example, we start with the constitutional changes. This is something that we would want to promote, for instance. And then we start sort of unraveling and coming to the point where they actually we'd need to consider the state of the entire legal system of Ukraine. It's like an underlying sort of a background that needs to be also worked on before we can arrive to the point where we can advocate for constitutional changes, because there's problems with impartiality, independence, these basic things, and Liz, are you there? I mean, correct me if I'm wrong, but I think we discussed these issues, and I think they're important as well. And this is something that we'd need to figure out along the way.
I think that's right, Nadia, and perhaps we can come back to it in the discussion. Priya, I thought what you said about a coalition being one tool, one strategy to work on political will, which I think everyone has mentioned is so important, whether it's for legislative changes, for resources to support truly independent and impartial investigations, defense rights. It's clearly a key element. And the idea of civil society coalitions as a strategic approach to generating, sustaining that political will is a very important one. And I would just be curious, if we have time in the discussion, to talk through a little bit some of the lessons and examples as to when a formal coalition is the right approach, and when, you know, more flexible networks that can come in and work around specific needs are more desirable. You know, how to choose that, how to go about thinking about common principles, when do those get developed, how are they articulated. I can see advantages from other experiences to formal coalitions, particularly in sustaining that work and perhaps having that further effect on broader issues, creating a broad constituency. But I can also see that flexibility and the ability to adapt to changing circumstances could come from something that is not formally called a coalition. So I'd love to hear more about the particular experiences of how civil society can play a role in generating, sustaining political support, and also, of course, interacting with mechanisms once they are established to hold them to the highest standards. Thanks so much.
Thank you for that, Liz. I mean, I think there are so many questions to unpack from this whole, context of coalitions. As you say, I mean, I think it really needs to be a very strategic decision, because otherwise there are loose networks in any case. And I think, many organizations in this space work with each other already and sort of depend and rely on each other as well. So I think, in a way, the strategic decision to, say we go down this formal coalition route is really with a very clear purpose and with a very clear idea of, what the longer term implications are going to be and what the longer term sort of idea or plan is. And I think in the Asian context, of course, there really have been a lot of gaps. And I think that the need was felt to say, look, we need to do this in a more formal and structured way, while we all in any case work together, and the networks are there already. But I think it was also a matter of leveraging the national, the regional, and the international as well. So I think that becomes important as well. And again, another approach. I mean, a coalition might be a grassroots coalition as well. So again, you've got this range of options, I think, that we can choose from. And I think in terms of advantages, disadvantages, yes, there are many learnings from both. And I think the way to do it probably is, from my limited experience, is, in the governance structure, when you're thinking about it, everybody's at the table and everybody contributes to that discussion to make sure that they are clear how they want the coalition to function, and that the coalition is their coalition. The coalition is one of the organizations that constitute it. And so that there's that sort of stake in ensuring that it functions well and ensuring that, everybody comes to the table wanting it to succeed and wanting it to meet certain goals and aims. So I think that's a key part of it. And for our coalition, the Asia Coalition, everybody was involved in discussing these guiding principles and making sure that the question of independence was very clear. So yeah, we had a lot of engagement, and we took a few months actually to discuss and sort of formalize it as well. So I'll leave it at that, but I'm happy to sort of discuss this in a lot more detail. There's a lot to chat about.
Okay, I'm sure we'll continue this conversation just in a different format. Thank you, Priya, and thank you, Liz. So we've heard so far from the domestic legal representatives. We've heard from the experts on the possible accountability mechanism and challenges and how to tackle them, and the role of the political will in all these processes. But I think we shouldn't forget that the reason why we're having this discussion in the first place is because of the International Criminal Court and the role it's been playing in our legal system since 2015, when the preliminary examination was opened into the situation in Ukraine. And I think it's important to acknowledge the driving force of the court behind, these discussions. Okay, we haven't got that far with these processes, but this is something hopefully that's going to be changing gradually in the future. And it would be very interesting to hear from Rod about the situations where there were or there are accountability mechanisms in place, and how they sort of interact and cooperate with the ICC, whether it makes a difference for the court, or it doesn't really make any difference at all, and the ICC just does what it does, and the rest just falls on the domestic systems, and how they deal with it is their own business. Rod, the floor is yours.
Great, thank you very much, and thank you for the invitation. So yeah, I mean, in terms of the debate, I think what everyone has said resonates with also how the Office of the Prosecutor here at the court approaches complementarity. Indeed, I think there is often a very high expectation on international organizations of assuming the burden of addressing criminality, but of course we know that those expectations can often be so high that they cannot be met. And even with the Yugoslavia and Rwanda tribunals that were dedicated to single situations for 20-25 years, even there, as Eric mentioned, there was a need for national mechanisms also. The bulk of cases, I worked in Bosnia for many years, the bulk of cases still remains at the national level, even though a very significant number of cases were done. Obviously, the leadership cases were done at the Yugoslavia Tribunal and the mechanism now. So this need for a national response, whether it's with international assistance or purely domestic, and those different options, will always remain, irrespective of whether or not the court opens an investigation. I mean, for the ICC, in terms of Ukraine, as we said last year, we have identified obviously crimes within the jurisdiction of the court in relation to both Crimea, Eastern Ukraine. We have taken note of the national authorities' measures and efforts to combat criminality. Our assessment is similar to panelists' contributions from the Prosecutor General's office and from the Supreme Court, that there are some obvious challenges at the national level for the competent authorities to investigate and prosecute some of these crimes. This would appear to indeed indicate that there may be a role for the court in relation to contributing to combating criminality or accountability, to helping foster accountability in relation to Ukraine. And we also mentioned last year that we hoped to be able to come to a conclusion on our assessment on the preliminary examination this year. And so, of course, it's the time of the year when we normally make announcements about the status of preliminary examinations. So there will be an announcement later today on where we stand with that. But just to say, indeed, I think even if the court opens an investigation, the issue of complementarity remains essential, as everybody has said, because the court, of course, will not be able to assume the entire workload and the bulk of the cases. The court, as you know, is a relatively small institution. The idea of the court is very strong and large in our minds, but the reality of the court is that it is an institution with, of course, limited capacity and resources, and stretched over multiple situations, and typically always stretched. I think the chronic funding situation of the court is well known. And the criticism, I think, generally is that the court is trying to do too much, or that the Office of the Prosecutor is trying to do much and should actually reduce activities. So certainly, if the ICC was to open investigations, if the Office of the Prosecutor was to open investigations, obviously that would be a serious effort and an effort to identify which cases to focus on in terms of lines of inquiry deserving investigation, in terms of the level of gravity, quality of evidence, a realistic prospect of conviction, and so on. But that would only result in even in the best scenario, it would only result, obviously, in a limited number of cases being heard before the court, before the ICC. So even in the best case scenario, there will, of course, be the need for a national response. So I think all of the things that have been said here are things that certainly we would support and encourage as the ICC, and would seek to work with the authorities. I think that's also what we see in other situations. And indeed, I'll take up the invitation of reflecting how the court has in practice operated in other situations. I think this scenario of a complementary relationship between the ICC and the national level, in the manner also, as I say, Eric noted, in relation to a number of different situations, it has to also be something that operates at the level of the ICC. And we've had some limited experiences, because in some of the situations where we operate, the national response is it's so defective, sometimes because of sheer incapacity, because territory is under control of an opposing force, or there is lack of governance in certain areas, so the authorities are unable to even access territories. Or there are issues relating to the willingness of the authorities to combat certain types of criminality, or sometimes just a sheer absence of activity. In those situations, even though the court might be keen to talk about working together to address impunity, sometimes that conversation it's too early, or it can't be advanced, because the national system is still struggling to deal with other matters, or with ordinary criminality, and to expect them to be able to take on these large-scale cases involving powerful actors, sometimes it may be a longer-term challenge that can't be immediately addressed. But certainly, you know, we are keen to engage in that kind of process, as Priya also mentioned and Liz mentioned, to help build and support this broader coalition, this network that can support the national process. Because also it's in our interest, it's in the interest of the court to have the national response strengthened and responding, because we will fail, the ICC will fail, if the ICC is the only mechanism that is expected to respond to these situations of mass atrocities. The ICC will be unable to respond to the full range of criminality. And it's also not the design, as you know, it's not the design of the court to respond to everything. The court is complementary, and what that means, as you all know, is that the idea is that there is a shared response, shared by the international community as a whole, but also between the ICC and national criminal jurisdictions. This is so important that the very first article of the Rome Statute talks about the ICC being complementary to national criminal jurisdictions, as you know. So where we are able to, where there is a national partner or a coalition or a network of support that the court can work with, then certainly that's something that we seek to plug into. And we have varying levels of experience and success in some situations. Indeed, currently in the Central African Republic, there's a good opportunity for that, given the existence of a special court, which is also supported by international assistance. And we already have, we've been interacting with them for a number of years, even at the setup phase, and providing lessons learned, sharing experiences, going down to provide some exchanges, engaged in exchanges, having visits here. We've had that kind of exchange also with other situations that are not yet at the investigative stage, such as in Colombia or Guinea. We've had that interaction also with the Libyan authorities. You might know that Libya actually is the first state to have successfully, if you like, challenged the admissibility of cases before the court in the Al-Sanusi case. And that was a situation where when the challenge came through, the office, we looked at the national file and we did not oppose it because it seemed to indeed correspond to substantially the same conduct that we were investigating Al-Sanusi for. So in those situations, and sorry, just to say, of course, Libya was in a delicate transitional phase, still remains, with two rival governments in place, so hardly the most well-placed state to address this type of criminality, but was still nonetheless capable of challenging and of succeeding in that. And we have some other examples in the DRC and Uganda to some extent where we have interacted with the national authorities, shared evidence, sought to exchange lessons learned, and so on. So certainly the OTP, the Office of the Prosecutor here at the court is willing to do that, is keen to do it. We've stated that as a strategic goal from day one, from 2003 onwards, and we try to implement it with varying levels of success. And in terms of the final question that you had, our approach is not really to compete on these issues. And there have been examples where in the past we have changed course on our investigations because after interacting with the national prosecutors, with the national authorities, we were satisfied that they were handling that case satisfactorily, and there was no need for us to intervene or to overlap. And that case, if we had pursued it, it would likely have been rendered inadmissible because the national response was already effective. So there have been examples of cases where the suspects that were the focus of that particular inquiry as the evidence built and as the case hypothesis matured, some of the suspects were removed from our focus and the case proceeded at the national level. Or where, at an earlier stage, when there were multiple different suspects in a particular armed group, some of whom were already the subject of national investigations, we changed focus and examined where we could bring added value. Or even we've had situations where persons have been charged not for Rome Statute crimes, but for other serious crimes under national law. And even there, as a matter of our case selection and prioritization policy, we've said that that would be a reason to not pursue a case. If the national authorities have already pursued cases against the same persons or persons from the same organizations for similar conduct or for conduct which is a crime, a serious crime under national law, then that might be a reason why the Office of the Prosecutor should not pursue its own case, should again give deference to the national response as far as possible. So these are all considerations that we take very seriously, and obviously they have to be determined on a case-by-case basis. But I'll just conclude by saying I very much agree. I think even if the court announces that it intends to open an investigation, that's not the end of the story. Quite the contrary. That's the need to double up and re-emphasize the need for a close engagement between the court and the national authorities, and also to emphasize the need for the international community to indeed support and build this coalition to foster and strengthen accountability at the national level. So certainly these are all messages that make sense to us, and we would join.
Great, thank you very much. And I think also, considering the scale of the armed conflict in Ukraine, it's one of the situations, I think, where we have the selection of the armed conflicts, and they're all different. I mean, we'd like to think we have the common adversary, but in essence, the conflicts are, in Crimea and in Donbass, they differ. Yes, I think there's even if the ICC opens the investigation and you take the handful of the episodes, the rest is on us, and we got to do something with it. And I know that at the moment, I think we all agree in this room that the national legal system is not capable of tackling those cases and those challenges on its own. I think we will come to the point where we accept the fact that we won't be able to fare by ourselves and we'll need the assistance. And the sooner we realize it, the better, I think. Okay, thank you very much for this fruitful and exciting and interesting discussion. And it's always exciting to look ahead in the future, and especially when you see it as something bright and hopeful and optimistic. And but of course, we all have to put an effort into making it such. And I hope this is something that we are going to be staying on track towards, and yeah, we'll reach our goals, and we'll get to the point where we actually are able to say that we've reached the level of accountability and we've learned our lessons, and we finally can move forward. Thank you very much, everyone, and I'll see you soon.